This is Bloomberg Law with June Grasso from Bloomberg Radio.
It's been 3 years since a white supremacist opened fire inside a grocery store in Buffalo and killed 10 people.
This tragedy shocked us. It devastated us. It pushed us to what we thought were beyond our limits. But it didn't break us. It didn't break us. Instead, it revealed a strength that runs deep in the veins of this city. The strength of a community that binds together and refuses to be defined by acts of hate.
The 18-year-old shooter pleaded guilty to all state charges and was sentenced to 11 concurrent life sentences. The federal case against him is ongoing. But survivors and families of the victims are seeking to hold social media companies responsible. They're suing internet giants Google, Meta, Amazon, and Reddit for publishing racist content that allegedly motivated the shooter to commit a hate crime by targeting people in a historically black neighborhood hundreds of miles from his home.
Our case is fundamentally about the isolation, obsession, lack of impulse control, and desensitization resulting from the neurological and psychological trauma inflicted on a teenager's brain by a highly addictive social media product.
And today, both sides were in a New York appellate courtroom where the social media companies are arguing that they can't be held liable for the racist content on their sites. The victims' families say the algorithms the internet sites use to deliver tailored content to users should be considered products under the state's product liability law. Here are the attorneys for the victims' families and Meta.
Anytime a manufacturer places a dangerous product into the stream of commerce that they reasonably know creates an unreasonable risk of harm to the public are liable under New York State products liability law. It's plain and dirt simple.
And there are two sort of foundational problems here that get us outside of the realm of traditional product liability. One is that communicating intangible information is not a product, and the second is that services are not products. And here we have both of those things. Product liability law is geared to the tangible world. That's the language of the seminal Winter case.
It would be a first in New York if a court found a non-tangible thing to be a product for purposes of liability law. My guest is Eric Goldman, a professor at Santa Clara University Law School and co-director of the High Tech Law Institute. Eric, can you tell us about the allegations of the plaintiffs in these cases?
The case involves the mass shooting in a Buffalo supermarket by a white supremacist. And the basic gist of the claims is that the shooter was radicalized on Facebook. And so in order to fit that into legal doctrines, there's a variety of different claims that the victims and families have made in order to explain what's wrong with that. Why does that actually create legal rights for the victims? So some of those include a claim that Facebook was negligent, that it should have done something different to protect the victims. And some of it is based on what we sometimes call products liability, that Facebook is a product that is dangerous, and as a result, any harm that's caused by a dangerous product can be attributable to the supplier of that product.
Are the plaintiffs bringing it under the product liability law in order to get around Section 230?
No, Section 230 is a defense, whereas the plaintiffs have to still figure out a claim that actually fits their facts. However, they do want to pick claims that are not preempted by Section 230, which says, in short, that websites aren't liable for third-party content. So the idea is that the plaintiffs are arguing that they're not suing to hold Facebook liable for the third-party content. They're suing based on Facebook's contribution to the radicalization of the shooter.
So when you think of product liability, you think of tangible objects, a mechanical device that injures you, something like that. Has a New York court ever found a streaming service or social media to be a product under the state's product liability law?
For decades, there have been legal theories that have held that the supply of physical items that are at risk of causing physical injury are liable for those physical injuries. And one of the classic old cases involved exploding Coca-Cola bottles. And if you didn't manufacture and fill the Coca-Cola bottle properly, it could literally explode and create shards of glass that were projectiles. And so the idea is that we want manufacturers to be more careful in the manufacture of an item like that because of the physical risk it poses when that item is now in consumers' homes. There's a very bright line in those doctrines between physical items that are capable of causing physical injury and intangible things or services, which do not pose the same risk of sending glass shards as projectiles because there's literally nothing like that in their possession. So the laws normally limit products liability theories to actual physical products, not to services like internet services like Facebook. So it's a leap of the theory to try and expand it to cover services. This theory wasn't designed for that purpose. It's not optimized to do so. And unlike the regulation of Coca-Cola bottles exploding with glass shards, there's significant speech implications if we try to regulate the dissemination of information as if it's an exploding Coke bottle. So there have been plaintiffs across the country that have been trying out the theories that internet services are subject to products liability doctrines, and courts have split on that issue. Most courts have rejected it. Some have entertained it, and so it's a live frontier in internet law today.
And have there been rulings by appellate courts on that?
Yes and no. There's been a variety of rulings in different fact circumstances, but there's a leading case in this area that just came out in February from the Fourth Circuit. It involved a very, very similar case involving a shooter who allegedly was radicalized on Facebook, and the plaintiffs argued products liability as part of the reasons why Facebook should be liable. And in that case, the federal appellate court shut all that down and said that Facebook qualified for Section 230. Everything that the plaintiffs were arguing was trying to hold Facebook liable for the third-party content available on its service, and therefore the plaintiffs lose. So the plaintiffs in this case aren't directly bound by that ruling, but clearly there's a strong message from that ruling that the plaintiffs' arguments should not be successful.
Does that issue depend on the state's product liability law? Because those laws differ from state to state.
It can. We have to look at the terms of the exact statute, what it says it covers. That may very well restrict plaintiffs' claims but not expand them. In other words, there's some limit to the theory that as far as it can go, at some point it has to stop, either because of doctrines like Section 230, which Congress enacted as a way to prevent that kind of expansion, or because of the First Amendment, that the Constitution does not permit a physical-based legal doctrine to extend to the dissemination of speech.
If the court allows the case to go forward, will the plaintiffs have to prove that Facebook or the other platforms led to the radicalization of the shooter, and how difficult will that be?
Definitely, they'll have to show that what we call causation when it comes to negligence. I believe that will also be relevant in the context of strict products liability. And it will be difficult. And causation was also an issue in the federal appellate court ruling I mentioned from the Fourth Circuit. And the court independently said there was not sufficient causation in that case. And when we think about what causes someone to radicalize into a white supremacist, and even worse, what causes a white supremacist to then decide to engage in mass murder, there's so many things that contribute to that outcome, and it's very difficult to pull out one piece and say, that's the cause, they should bear all the burden of responsibility. In fact, it really is a whole of society failure to have people who end up in that circumstance, and we really need to look at our society across the board to figure out what went wrong and what we ought to be doing differently. And to try and pin it on any one player in the ecosystem, to say Facebook was the reason why this particular person pulled the trigger, I really think kind of denies the reality of how we've all contributed to a society that can lead to these outcomes.
And explain how Section 230 would work here as a defense.
So the plaintiffs are arguing that Facebook radicalized the shooter, and Facebook itself normally doesn't publish content itself that it authored. Its primary way of engaging in content distribution is to gather third-party content, like the Facebook post that we all make as the everyday activity, and then share that with an audience. And so the content that allegedly radicalized the shooter didn't come from Facebook. Facebook at most was the mechanism by which some author matched with the shooter. And so it's impossible really to describe Facebook's role in radicalizing the shooter without talking about the content that radicalized the shooter, all of which came from a third party. And if third-party content can't create liability for Facebook, Section 230 will apply.
A note, Michael Bloomberg, the founder and majority owner of Bloomberg LP, the parent company of Bloomberg Radio, is a donor to groups that support gun control, including Everytown for Gun Safety, which represented the plaintiffs in this case in the lower courts. Coming up next on the Bloomberg Law Show, I'll continue this conversation with Professor Eric Goldman of Santa Clara University Law School. We'll talk more about the algorithms at issue in the case. Survivors and families of the victims of the mass shooting in a Buffalo supermarket 3 years ago are suing internet giants Google, Meta, Amazon, and Reddit for publishing racist content that allegedly motivated the shooter to commit a hate crime, targeting people in a historically black neighborhood hundreds of miles from his home. The plaintiffs blame the proprietary algorithms the companies use.
Putting people in groups, there's something called confirmation bias. And when you put people in groups where they're getting these white supremacist theories and these calls to violence and these calls to make a race war and think that that's the right thing, that's what happened to Peyton Gendron. And that's what this lawsuit is about.
But the internet companies say they're protected from liability under the law, which says no interactive computer service provider can be treated as the publisher or speaker of any information provided by another information content provider. I've been talking with Professor Eric Goldman of Santa Clara University Law School. Eric, tell us about the plaintiffs' claims about the algorithms.
So in order for the shooter to get access to the radicalizing content, somebody has to upload it, and then Facebook has to make the match to present that to the reader, to the shooter in this case. And so plaintiffs have often claimed that it was the algorithm Facebook created that led to this radicalization. Now, there are a couple of problems with that theory. One is it was expressly rejected in the Fourth Circuit opinion that I mentioned earlier. Federal appellate court said that's not a way of getting around Section 230. The other piece, and the appellate court mentioned this as well, that in order for Facebook to do anything differently to prevent that radicalization, it would have to re-architect its entire service. In other words, there's not a way of it just changing the algorithm to eliminate, the risk of radicalization without changing any other element of its algorithm. So, in other words, there's no easy fix here for Facebook. Facebook worked the way it was designed to work. It made matches between people and content they might be interested in. Unfortunately, some people are interested in content that is antisocial. Facebook's algorithm treats that the same as all other content.
The director of the Center for Democracy and Technology's Free Expression Project, which filed an amicus brief in support of the social media companies, said if the automatic ranking and delivery of content is separated from the Section 230 liability shield, it will suddenly make many pieces of content open to liability and incentivize platforms that use automated ranking systems to deliver content to suppress or eliminate delivery of content they're worried about. So basically, would there be a chilling effect if that happens?
I think that's a riff on what I was just saying, and maybe you said better than I did. But let me take another cut at it. So if Facebook is liable for radicalization content, and if, and I'm going to hypothesize this is true, people might debate it, there is no way for Facebook to know which content is radicalizing or not, or to properly separate that from the pro-social content that it would prefer to disseminate, then Facebook basically becomes the financial guarantor of any harms that are caused by people that could be traced back to someone's consumption of content on Facebook. We've seen so many cases in this genre. This is not a unique case in Buffalo. Many times, victims of shootings have claimed that the shooter was exposed to content on social media and social media should be responsible for this. And that's just not tenable. Social media cannot act as the financial guarantor of all the shootings that take place in the world. So then they have to do something different. If they become the financial guarantor, they cannot exist in their current form.
The easiest path for the appellate division right now in this case is to allow the case to go forward and to say, the facts have to be developed before we can make a decision on whether or not this is subject to the state's product liability law?
So that's essentially what the lower court did. The lower court basically said, I understand Facebook's defenses, and yet I need to see more facts before I'm prepared to make the conclusion that products liability applies or even that Section 230 applies. So one possibility is that the appellate court could say, the district court was right. Let's let the case continue to evolve in its ordinary manner. And once we get more information, then we'll be able to figure out what defenses actually apply in this circumstance. Most cases involving Section 230 don't do that. Most cases in Section 230 end at the motion to dismiss because it is obvious on the face there's nothing that would be produced in discovery that would show that Section 230 didn't apply. And here, I don't think anyone's contesting that Facebook provided or authored the radicalizing content. The allegation is that it matched the shooter with third-party content. So everything that the court needs to know about Section 230 is, I think, already available to it. So punting on that question actually would be a disservice to Facebook and I think to all other social media that expect to be able to avoid liability for things that they're not legally responsible for.
It's interesting that the plaintiffs here chose state court, where in the other case you were discussing, the plaintiffs chose federal court.
Plaintiffs get to pick the venue that they think is the best place for them to achieve justice. Mm-hmm. So it's completely logical that they might conclude that New York state courts as opposed to New York federal courts are a better venue for them. But I would hope that the New York state courts will still take a look at what's going on in the rest of the country, because this is not a novel issue across the country. And the case law is very clear that the New York state trial courts got it wrong.
How important is this case as a precedent, let's say, for other cases around the country? I mean, is it important, or is it just, another one of the cases that you've been talking about? Is there any import to it?
So every case that involves the situation where social media allegedly contributed to some offline harm is important, because if those cases succeed, then all social media services face an extreme amount of liability that may make them financially untenable. So it's like the social media services have to bat 1,000 in these cases. If they only bat 999 and one case gets through, that one case could potentially change the entire internet ecosystem. So if this case ends up like essentially all the others and the plaintiffs don't succeed, then this case became unimportant. It's just one of the many. If, for whatever reason, this case does succeed, then this could be the case that reshapes the internet. And the district court opinion in this case was so troubling because it clearly deviated from precedent around the country, and because it basically said, I can't make any judgments, even though many people thought that the court had all the facts it needed to make a judgment. And so if that's the case, it opens up the door for unpredictable results, and that unpredictability is actually its own form of danger to the internet. Any
final thoughts?
The Buffalo shooting was horrific. All these mass murders are just heartbreaking. They're a sign of pathology in our country. They just absolutely tear me up. And the fact that the shooter was espousing the great replacement theory is even more troubling, that this theory continues to find an audience in our country when it's both afactual, but it's also deeply corrosive. I will add that people want to blame Facebook for the dissemination of the great replacement theory, but many leading figures in our country, whether that's media pundits or actual government officials, have also dabbled in the great replacement theory. And so, to me, the idea that Facebook radicalized this shooter misses the whole ecosystem.
We'll see if the New York Appellate Court here deviates from the way most other courts have ruled. Thanks so much, Eric. That's Professor Eric Goldman of the Santa Clara University School of Law. Coming up next on the Bloomberg Law Show, the growing trend of presidents using temporary appointments for top roles in government. President Trump has installed another loyalist in one of the most powerful U.S. attorney's offices in the country. Former Fox News host Jeanine Pirro has taken over as the interim U.S. attorney for D.C. from Ed Martin, who was the interim U.S. attorney for close to 120 days. The interim nature of both appointments tests the bounds of a federal statute governing temporary officials and reflects a growing trend of presidents leaning on temporary appointments for top roles in government. My guest is Ann Joseph O'Connell, a professor at Stanford Law School who specializes in political appointments. Will you explain the provisions that are at play when a U.S. attorney is given an interim appointment?
So when there's not a Senate-confirmed U.S. attorney in a particular district, there are two statutes that can provide for temporary service. So the first, what we call interim U.S. attorneys, is a specific provision in the United States Code called Section 546. And that provision allows for the Attorney General to choose a temporary interim U.S. attorney for the district in which there is not a Senate-confirmed person. There are no restrictions on who the Attorney General can pick, so they don't have to pick someone who's within the Department of Justice, unlike this other statutory provision. And so the Attorney General can pick an interim U.S. attorney, and that person can serve for 120 days under Section 546. And then after that 120 days expires, the district court may appoint a U.S. attorney to serve until there is a Senate-confirmed one.
So what happened here is the term for Ed Martin was about to run out. And before the district court could appoint someone, President Trump nominated as another interim U.S. attorney, Jeanine Pirro. I mean, is that according to the rules?
Well, it depends whether you're looking at the text of the rule or the intent of the provision. Under the text, I think it's permitted. The provision, Section 546, does not explicitly bar successive 120-day appointments. And I should also note that even if the district court had chosen someone, the president, in all likelihood, could have fired the district court pick and picked another interim U.S. attorney or turned to this other statute, the Federal Vacancies Reform Act. So I think the text permits successive appointments. There's no explicit bar on it. There's no provision that provides for a penalty if you see these successive appointments. And in the past, we have seen successive appointments. Now, that's the text. When Congress reimposed time limits, so put back the 120-day constraint on how long interim U.S. attorneys can serve, they did that in 2007 after a U.S. attorney scandal involving Attorney General Alberto Gonzales, who had fired a number of U.S. attorneys. And the scandal was not whether the president or the Attorney General could fire U.S. attorneys. It was about the reason that was given for those firings. But at the time that it happened, there was no limit on how long interim U.S. attorneys could serve. And this had occurred after September 11th. There was a period of years where there was kind of no time limit. But then in 2007, Congress put back this time limit. And I think the putting back of the time limit suggests strongly that the intent of Congress was not to have endless interim appointments of U.S. attorneys.
And was that the intent of the framers as well? In other words, they wanted the Senate to advise and consent?
So we have had Senate-confirmed appointments since the start of the United States Constitution under the Appointments Clause. And interestingly, we've had statutes that provide for temporary appointments from about the same time. The very first Vacancies Act, which applied generally, was in 1792, and there was another one in 1795. There it gets a little tricky about kind of what were the time limits, because in the 1795 Act, Congress imposed a 6-month time limit on acting officials.
You hear a lot of actings. Have U.S. presidents been using interim positions more and more?
So I have done some research on recent administrations and looking at the very highest level of positions, so the heads of agencies, cabinet secretaries in particular. And definitely recent administrations, and that would include President Obama, President Trump's first term, and President Biden have heavily relied on acting officials, much more, I would say, than their predecessors in terms of modern government.
What's the reason for this? I know that President Trump in the past has said, he likes the idea of it. Is it because it's difficult to get people through the Senate? I mean, what's the reason that they're using it more?
I think there are several reasons. The first is it takes time to nominate people, though I will say that President Trump in his second term has a much faster nominations pace than he had in his first term. I mean, in 6 or 7-fold more nominations at the 100-day mark in his second term than in his first term. But nominations still takes time to find the people and to formally nominate them. There's a vetting that occurs. And I think for President Trump, that vetting has really focused on loyalty, whereas in other administrations might be focusing on ethical considerations, expertise, and the like. And then there's the confirmation process. And so even as we have now, and even as we did for President Biden, have a Senate controlled by the same party as the White House, it still takes time because individual senators, even though there's no longer a 60-vote threshold to move a nomination to a confirmation vote, that went away in November of 2013, individual senators can still delay the confirmations process. Right. And we saw this with Senator Tuberville in the Biden administration. We've seen this in other cases as well. Right. Democrats do it to Republicans. Republicans do it to Democrats, and that can slow it down. And so I think both the nominations and confirmation process make acting officials attractive. But I would also say that what I think is a large reason is that acting officials don't require Senate confirmation. And so you can pick people to serve in a temporary capacity that the Senate might not confirm. So in President Trump's first term, the Republicans, as reported by the media, did not want to confirm Ken Cuccinelli to a senior post in the Department of Homeland Security, but through acting appointments and delegations of authority, Mr. Cuccinelli was able to serve in very high-profile roles in DHS. And I think a similar story, right, for Ed Martin, that Republicans balked, and he was able, through the interim provision, to serve, whereas, if he had just been put up as a nominee, not as an interim, he might not have gotten through.
Has President Trump pushed the limits of the Vacancies Act further than other presidents?
I think the Vacancies Act is pretty capacious. It allows the government to function. I think the Vacancies Act should be reformed in certain ways because I think it allows more than perhaps what we want for an accountable government. But I think in this term, President Trump is really pushing an argument that no previous president has pushed, which is that he believes that if the Vacancies Act does not apply, he has inherent Article 2 authority to name acting officials. And this has come up in the Inter-America Foundation and the African Development Foundation. These are entities not covered by the Vacancies Act, where President Trump has named acting officials to Senate-confirmed board positions, relying on claimed inherent Article 2 authority. It seems with the firing of the Librarian of Congress that if the Library of Congress is not subject to the Vacancies Act, and I don't think it is, President Trump, the White House has indicated that there is Article 2 authority to name an acting librarian. And I think this is an outrageous claim. We have an appointments clause. We have a recess appointments clause. It is true that the Vacancies Act and specific agency provisions like Section 546 for interim U.S. attorneys do allow vast use of temporary appointments, but outside of those, presidents need to rely on the appointments clause or the recess appointments.
So some are saying that with the U.S. attorney, for example, with Jeanine Pirro becoming the second interim U.S. attorney for D.C., that defendants might be able to challenge some of the, prosecutions, et cetera, under her because of this issue?
I think they would definitely have standing to sue. And I think their argument would be that under Section 546, successive 120-day appointments are not allowed. And I think that is a plausible argument. I just don't think it's a winning argument. I think that courts will look at the text right? As Justice Kagan says, we're all textualists now, that the courts will look at the text and see that successive 120-day appointments are not barred. It's happened in the past, and permit it. Now, that doesn't mean it shouldn't change. I mean, Congress could amend 546 to make it clear that you get one 120-day appointment, then the district court gets to choose. And then I should note that there is an alternative to these successive 120-day appointments while a nomination might be pending to a U.S. attorney slot, is that I believe that the Federal Vacancies Reform Act is available for temporary appointments to these positions. Now, the constraint, why I think the Trump administration doesn't want to turn to the Vacancies Act, is that under the Vacancies Act, you can't just choose anyone. You can't choose an outsider like the current person. You can't choose an outsider to come in as an acting U.S. attorney. You either need to choose someone who is the first assistant to the U.S. attorney, right, which is typically a career person. You need to choose someone who is Senate confirmed already to another position, so has already kind of gone through the Senate process, or you have to choose someone who was in the agency for at least 90 days in the year before the vacancy.
So finally, you think there needs to be reform here?
I think the laws governing temporary appointments are pretty broad and likely too broad. On the other hand, we want the government to function. We don't want the government to come to a standstill. And so finding the balance between getting Senate-confirmed appointments through a dysfunctional appointments process and having the government function is tricky. And sometimes we're on the right side of the balance, and sometimes we're on the wrong side of the balance. And so I think that Congress really has a role to play in constraining the use of acting and interim appointments.
So we'll start counting now to see if Jeanine Pirro is nominated to be the permanent U.S. Attorney for D.C. before the 120 days expires. Thanks so much for joining me today. That's Professor Ann Joseph O'Connell of Stanford Law School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.